On Monday, 18th of April 2011, designated single judge of the pretrial Chamber 2 of the International Criminal Court, Ekaterina Trandafilova, held a status conference in the case of the prosecutor versus William Samoei Ruto, Henry Kiprono Kosgey, and Joshua Arap. This is the first status conference after the initial appearance on the 7th of April 2011. It was held without the three suspects since the Chamber did not request their presence on this hearing. However, they were represented by their respective defense team for this hearing. The status conference was held in preparation for the confirmation of charges hearing that the pretrial chamber provisionally scheduled to commence on 1st of September this year. Cynthia Tai, senior trial lawyer, informed Judge Trandafilova that the Office of the Prosecutor intends to call witnesses to testify during the confirmation of charges hearing and present approximately 4,700 pages of full witness statements.
We can only provide an estimate at this time. We can provide the court with no more than 10 live witnesses. That would be our approximation at this time.
The floor is over to you, Mr. Hupi, if you would like to make a point.
The confirmation process will be contested. It will be strongly contested. And so as a product of that, the Chamber can expect that there will be live witnesses. We are, despite, as I think the Chamber knows, various efforts that have been made over the past months, still very much in the dark as to the nature of the evidence against us. And until we have disclosure, we're really not in a position to know which parts of the prosecution case are parts that we would contest and contest through oral testimony. So we would think that at the moment a minimum of about, and this is just an indication for the Chamber, of about 15 oral witnesses seems, in respect of this part of the case, likely. And I speak, of course, just in respect of Mr. Ruto at this stage.
Defense team of Mr. Kosgey. Counsel Oraro?
Yes, I would wish to make a couple of comments. First and foremost, as the Chamber is well aware, the application for summons was based on evidence which was very heavily redacted. So as we are not conversant with the evidence which will be led against the suspect. And once we have the evidence, we shall be compelled to investigate, test, consider, and see how many witnesses we can summon. The only proposition we can make for the moment is that as the prosecution have indicated that they intend to call witnesses, we shall definitely call witnesses in rebuttal to the extent that any evidence by those witnesses implicate our client. That's the comment I would wish to make.
Thank you, Counsel Oraro. I now turn to the counsel of Mr. Sang. Counsel Mr. Katwa.
Madam President, we propose to call live witnesses in rebuttal to what the prosecution evidence will have brought out. Tentatively, we may call 15 witnesses. We propose in every likelihood to produce our witness statements in full, not redacted. We are not in a position to comment on how many pages our bundle of response would be, because that would depend on what the prosecution will say. Madam President, that would all depend on three issues. The first one is the extent of the disclosure the prosecution will give. The second issue, Madam President, is that we will pray that as the court sets up the calendar, it takes into account its ruling on our access to defense witnesses in its ruling as to access to witnesses. And we would wish to point out at this point that the 15 days prior to hearing, considering that ruling may not be adequate, and we pray that that accommodation be taken into account.
The Office of the Prosecutor announced that it is in the possession of 185 items constituting material evidence in this case. According to the ICC rules of the procedure and evidence, the prosecutor has to permit the defense inspection of this material in preparation for the confirmation of charges, hearing, or trial.
I would ask the prosecutor whether the prosecutor intends to request that certain documents be disclosed to the defense in a redacted form.
We do have an estimate of materials that would be disclosed in redacted form, or that we wish to disclose in redacted form.
You remember that you make proposals to the chamber and, of course, substantiating your proposals, and finally, it is the chamber's responsibility to approve these reductions.
That's correct, Madam President. We understand.
And the approximate amount?
606 documents, and we have calculated the pages at this time to be approximately 11,000 pages.
Mr. Hooper.
So what we'd ask and exhort, as I know I think is probably reflected in the Chamber's own view, is that the prosecution approach this issue of redactions with very great care, and that they only redact what in the long term is going to be properly justifiable in hindsight as a redaction made, as I understand it, solely for the protection of particular witnesses.
The Chamber is going to scrutinize very carefully the approach of the prosecutor, and we are going to take the appropriate decision so that we safeguard the rights of the defense to properly prepare for trial. Mr. Oraro.
Madam President, I would first wish to make a few factual observations. As a matter of fact, the prosecution from the commencement has contended that it had taken protective witnesses and flown most of the witnesses outside the country, and that was repeated as late as last week by the chief prosecutor. So in looking at application for protective measures and reduction, I do think that that's an issue which ought to be taken into account and clearly brought by the prosecution to the attention of the chamber.
Thank you. Then we proceed with Mr. Katwa.
Madam President, we tentatively confirm that we may have some requests for protective measures of some of the witnesses, but we can't say that for a fact now, depending on what becomes of the disclosure. It is unlikely that we will seek any reductions of any of the documents. Madam President, we pray that when the motion for protective measures is brought, the court do take regard of what Mr. Hooper has said, and which we share, being the extent to which those protective measures may be in themselves an inducement to make representations that are not necessarily accurate. And this is an issue which we will take up in the course of time.
As I said, the chamber is in charge with all these issues, and we are going to very, very carefully, diligently, and with due respect for the rights of the accused and respect for the lives and security of victims, witnesses as well, and other persons at risk, finally take our decision.
It is the prosecution's position, of course, that the disclosure of these documents should only occur after protection measures are in place and after a final decision is made on the challenge to admissibility, which is pending before the chamber presently.
The chamber is going to deal with this issue because the prosecutor raised it twice during the two cases. There were explanations based on the law, namely Article 19, Paragraph 8 of the Rome Statute. Still, we have received from the prosecutor in writing an application to this effect, and the chamber is going to take a decision quite soon on this issue. And is going to guide the prosecutor's team in this case how to proceed with disclosure.
Judge Katerina Trandafilova announced that the Chamber will issue a decision on the disclosure calendar soon.